They decided, especially when you have a case that's this controversial, a country that is polarized, the issue of race associated with it, you play it safe and go for what you know you can prove without offending anyone or offending the court or making your case more difficult. So my educated guess would be the state realized it would be easier to prove guilt beyond a reasonable doubt based on these facts and to not seek the death penalty.
Marcia, thank you kindly for that. Dawn, I want to pick your brain, please, about what lies ahead for these defendants. We know this is far from over for them and really for Ahmaud Arbery's family, too, because there's still that looming federal case. The family's been through so much, and these defendants have been charged with violating federal hate crime statutes as well, stemming from the same incident. Talk to me, please, about, from a defense perspective, what you do in assessing what's going on with the state court case and then looking ahead to what you know is coming in federal court.
What I think you've got to do as a defense attorney for these gentlemen is really honestly evaluate the likelihood of success on appeal. And it's going to be a tough appeal, quite frankly. So then you try to minimize your damage and work out some kind of a deal on the federal hate case and hopefully run something concurrent, maybe a sentence under 10 years if you possibly could. If you could do that, you've served your client well. That's a difficult task.
Sure. Don Malarstick and Marcia Minot, great insight from you both. Thank you so much. I'm being told that court is back in session in Brunswick, Georgia. We are going to go live now to the sentencing hearing again for the three men who have murdered Ahmaud Arbery. They've been convicted in state court, all three of them, of the crime of felony murder. That is one thing they all have in common. And we can see that the attorneys have taken their seats at the respective counsel tables. We have no word yet as to whether or not the judge has taken the bench, but I believe we can show what's going on in court. Let's go there live if we can.
Your Honor, I want to begin by just addressing some case law that seems to apply to the, I want to say, piling on of the additional felonies, and that they do not merge, which is the state's position. I point the court to Noel versus the state, 297 Georgia 698, a 2015 case. And it says, in fact, what Ms. Dunikowski's position is, that the additional felony murder counts will be vacated by operation of law when they involve the same victim. But in that case, there was, as there is in this case, additional felonies, which in Noel, there was a question about whether the trial court should have also sentenced and not merged those into the felony murder counts, which were vacated by operation of law. I want to make a separate argument. This is the first time we heard of this morning. I know of no law that prohibits the court from conducting merger before the vacating of the by operation of law. So in other words, if you were to merge the underlying felonies into the felony murder counts, and then those counts are vacated by operation of law, we don't even need to consider this. But in Noel, this Georgia Supreme Court case, this court concluded that the trial court had failed to sentence on the underlying felonies that were the predicates for those felony murder counts that